Hello everyone. So today I'm going to deal with the topic essential sales versus agreement to sale. Before understanding the essentials of sales, let us first understand the meaning of contract of sales of goods. Contract of sales of good is a contract whereby the seller transfer or agrees to transfer the property or goods to the buyer for a price. That is, the transfer of good takes place for consideration. The term contract of sales is a generic term and includes both sales and agreement to sales. Now, let's understand sales and agreement to sales. Here, in the contract of sales, the property in the goods is transferred from the seller to the buyer. The contract is called as sales. But where the transfer of the property in the goods is to take place at a future time or subject to some conditions thereafter to be fulfilled, the contract is called as agreement to sale. It is given in section 4, subsection 3 of the Sales of the Good Act. In other words, agreement to sale refers to the sale of goods which takes place in future date on fulfillment of certain conditions of the content. Essentials of contract of sales. It consists of following elements necessary for a contract of sales. First, two parties. Second, goods. Third, price. Fourth, transfer of general property. Fifth, essential elements of a valid contract. Coming towards the first, that is, two parties. There must be two parties in the contract of sales, that is, the buyer and a seller. A buyer means a person who buys or agrees to buy goods, given in section 2, subsection 1. And a seller means a person who agrees to sell goods, as per section 2, subsection 13 of the Goods Act. Second, goods. There must be some goods, that is, the property that needs to be transferred from the seller to the buyer. These goods must be movable. Third, price. The consideration for the contract of sales is called as price. The consideration is in the form of money. When goods are exchanged for goods, it is not a sale, but a barter. However, the condition may be in form of partly money and partly in goods. Transfer of general property. There must be a transfer of general property as distinguished from special property in goods from seller to the buyer. For example, if A owns certain goods, he has general property in the goods. If he pledges them with B, B has special property in the goods. Fifth, essential elements of a valid contract. All the essential elements of a valid contract must be present in the contract of sales. Sales and agreement to sales. Distinction is made on following basis. First, transfer of property. Second, type of goods. Third, risk of loss. Fourth, consequence of breach. Fifth, right to resale. Sixth, general and particular property. Seventh, insolvency of a buyer. Eighth, insolvency of a seller. First one, transfer of property. In sales, the property in the goods passes from the seller to the buyer immediately, so the seller is no more the owner of the goods sold. Whereas in an agreement to sales, the transfer of the property in goods is to be taken place after a future time or subject to certain condition to be fulfilled. In this sense, a sale is an executed contract and an agreement is an executory contract. Second, type of goods. A sale can only be in case of existing and specific goods only, whereas in an agreement to sale, the goods are mostly of future and contingent goods. Third, risk of loss. In a sale, if the buyer goods are destroyed, the loss falls on the buyer itself, even if the goods are in the possession of the seller. In an agreement to sale, the loss falls on the seller even though the goods are in the possession of the buyer. Fourth, consequences of breach. In a sale, if the buyer fails to pay the price of the goods, or if there is a breach of contract by the buyer, the seller can sue for the price even though the goods are in his possession. In an agreement to sell, if there is a breach of contract by the buyer, the seller can only sue for damage and not for the price, even though the goods are in the possession of a buyer. Fifth, right to resale. In a sale, the seller cannot resell the goods, but the buyer of the goods have the right to sell. In an agreement to sell, the seller have right to sell the goods. Sixth, general and particular property. A sale is a contract plus a conveyance and gives right to the buyer to enjoy the goods as against the world at large including the seller. In an agreement to sale is a merely a contract, pure and simple, and gives right to the buyer against the seller to sue for damage. Seventh, insolvency of buyer. In a sale, if the buyer becomes insolvent before he pays for the goods, the seller, in the absence of lien over the goods, must return them to the official receiver or assignee. He can only claim a rateable dividend for the price of the goods. In an agreement to sell, if the buyer becomes insolvent and has not yet paid the price, the seller is not bound to part with the goods until he is paid for. Eighth, insolvency of seller. In sales, if the seller becomes insolvent, the buyer becomes the owner, is entitled to recover the goods from the official receiver. In an agreement to sell, if the buyer, who has paid the price of the good, finds the seller has become insolvent, then he can only claim a rateable dividend. With this, we have come to the end of the slide.